Welcome to the Hoover Institution workshop on using text as data in policy analysis. My name is Stephen Davis. Justin Grimmer and I moderate the workshop and select speakers. Tara Mahin makes everything run smoothly during the show, and Kathy Campitelli keeps us organized. Today's workshop features a paper on Ideas Have Consequences, the impact of law and economics on American justice. It's by Elliot Ash at ETH Zurich, Daniel Chen at Toulouse Institute for Advanced Studies, and Suresh Naidu at Columbia University. Here's our format. The authors present the paper over the course of about 30 minutes. I think Daniel will be doing the heavy lifting there. Then we will turn to discussion and Q&A. If you have a question or comment, put it into the Q&A box, which Justin and I will moderate. And depending on the flow of questions, we may combine them, paraphrase them, or ask you to state your remarks directly. We'll run for about 60 minutes in the recorded session. After that, we'll turn off the recording and continue with a more informal discussion for anyone who wants to stick around. Okay, Daniel, the floor is yours.
I want to start with a metaphor that's frequently used in legal education to illustrate the impact of law and economics. Some of you may know of the moral trolley problem, where an out-of-control trolley is going to kill these 5 people, and you as a bystander can switch to train tracks, saving the 5, but killing the 1. Most people are willing to do so, and this is usually interpreted as a utilitarian, consequentialist decision, maximize the lives saved minus those killed. In the classic variation, you're on a footbridge, and the option to push a large person off the bridge into the path of the trolley, killing the person, but saving the 5. Now, most people are not willing to do so, and this is typically interpreted deontologically. That is, people feel a duty not to do the act of pushing someone to their death. So in law and economics, there's a classic divide between the consequentialist view that optimal legal policies should be calculated in terms of costs and benefits, and the ontological view that judges have certain duties, and from these duties would derive the optimal legal policy, what's right and just. So this metaphor is frequently used in legal education, the idea being that the future lawyers, judges, and policymakers will frequently make decisions like these, evaluating trade-offs or following duties. Now, a decade ago, they ran an experiment at Yale Law School where students were randomly assigned to professors with economics PhDs and those with non-economics PhDs, and found that 1 in 3 years after economics exposure, students behave less pro-socially in economic games. Now, this small sample study is important as it suggests a potential mechanism for what Carl Polanyi might call the great transformation of American law. So in contracts, what used to be a general duty to keep promises became efficient breach theory. So if 2 parties are in a contract and one finds a better economic opportunity, they should be allowed to walk away, so long as it's economically efficient to do so. An idea articulated in a 1977 Law Review article that Richard Posner wrote into this 1985 circuit decision. In accident law, the duty of care can be defined economically when the probability of loss times the size of the loss exceeds the cost of taking precautions. So the principle underlying this is one of a least cost avoider. Is it less costly for you to take the burdens of preventing the accident than it is for the accident to happen to me, an expectation? And this principle can also apply to criminal law, where the probability of detection times the size of the sanction yields the expected sanction. So if I'm a judge and I approach a decision thinking that the cost of detection is really, really high relative to the cost of sanctions, then I may increase the sanctions if I approach as a social planner, which they do. As Richard Posner stated in the New York Times, I pay very little attention to legal rules, statutes, and constitutional provisions. The first thing you do is to ask yourself, forget about the law. What is a sensible resolution of this dispute? Then see if a recent Supreme Court decision or statute gets in the way. And even if they exist, they're often extremely easy to get around. So law and economics has been influential in criminal law, antitrust, labor law, even environmental regulations. And we've seen an increasing pro-market orientation in the US judiciary, as indicated by the increasing language similarity between court opinions and economic articles, an increasing tendency to vote conservative as hand-coded by American political scientists, and an increasing tendency to vote against government regulation, as regexed from the title of the court opinions. And this increasing tendency to vote conservative is especially pronounced in economics cases as opposed to non-economics cases. And then we see an increasing citation to Richard Posner, such that 15% of cases are now citing Richard Posner.
Daniel, I'm just starting to jump, but what do you mean by conservative? I know that word comes up all the time in the paper, but can you define it for us?
So conservative would be something like voting against a labor regulation that's to prevent child labor. It would be something involving, for example, are you choosing to block a anti-discrimination a ruling or case? There's a variety of things that the Sanger-Auburn database that has been hand-coded and hand-collected since the 1970s has done for creating this rubric for what's a conservative vote.
But is there a principle, or is it just in the 1970s what somebody decided was to call conservative? I struggled with it reading the paper, which is why I'm jumping.
Fair enough. That is it is a 1970s. Well, they also continued the database all the way into the 2000s. It is a point in time conception of what is conservative versus liberal. And of course, we'll want to move away from just relying on conservative versus liberal and think about more quote unquote objective black and white decisions that we can encode from voting against government regulatory agencies and so on and so forth, as well as their economics language. So what we want to do is to examine the impact of law and economics on moral reasoning and decision-making in this high-stakes setting, where we've seen these federal courts having the power to stall or stymie executive orders from the US president from taking place. The judges are tasked to interpret the law and make precedent, often under significant uncertainty. So that creates scope for schools of thinking, ideas, and normative commitments that form basis for policy. Economic theorists can model this as principles of thinking that agents use to organize their values, not unlike the heuristics that consumers use to focus on salient product attributes. So we think of law and economics as making salient deterrence and cost-benefit utilitarian analysis and examining its impact on American justice. So here's a map of the US federal courts, the 94 district courts indicated in dotted lines. There's up to 4 districts in a state. This is where cases first come to trial, and you have a jury. If there is an appeal, it goes up to one of the circuit courts indicating colors. There's up to 9 states in a circuit. And the name comes from the fact that the judges used to ride around on a horse in a circuit to reach the entire jurisdiction. And if there's an appeal here, it goes to the Supreme Court, which takes very few cases. So the circuit decisions are the majority of the rulings in this common law space, where the judges continually find new legal distinctions and new rules that future judges must follow. Judges are randomly assigned to cases to panels of 3 in the circuit courts where there are no juries, and they're appointed for life, roughly 180 in the circuit court at any given time, and 700 in the district courts. They get hundreds of thousands of cases per year, but only 100 reach the Supreme Court. So their circuit decisions are the majority of what law students are reading. Now, the influence of economics is partly due to a training program that received attention as early as 1980 due to its large corporate donors. By 1990, 40% of federal judges had attended this economics training program, despite going on the record to say they were swamped with criminal cases and didn't see the relevance of economics. Ironically, we'll see that economics impacted sentencing, which has undergone several moral revolutions, retribution and rehabilitation being out of favor relative to deterrence, which you can see in word frequency accounts in state court opinions and in Google Books. So in the 1800s, retribution was more popular, then followed by rehabilitate, and then by deterrence in the 1960s, when Gary Becker articulated the theory that sentencing severity can substitute for low detection probability. So what this research agenda does is to create textual measures of new ways of moral reasoning and trace their spread in the courts and impacts on the population. And for this work, it's involved digitization of all the circuit court cases, now 1 million judge votes, 994 legal topics since 1891, engineering of 2 billion n-grams of length 8 and 5 million citation edges across the cases. So create textual measure of ways of moral reasoning would be an 8-gram. And this is merged with the judge's biographical features and existing hand-coded, hand-collected data sets that can be useful for machine learning, but also to begin to validate, we can do something like textual measures of ways of moral reasoning. So for instance, in predicting liberal or conservative decisions, you can see that in campaign finance, liberal decisions would talk about influencing the outcome of the vote, disclosure of sources, for capital punishment, involuntary and mental health, and for environmental rulings, hazardous waste. Whereas for conservative decisions, they might talk about informing the electorate, attack, or the statute being silent or ambiguous. So we also have 1 million criminal sentencing decisions, FOIA requested to link to the judge's identity, and then crosswalk to the judge's biographies and the available corpora of their opinions. Now, this paper is going to focus on 2 sets of results. First, we're going to use the random assignment of judges to cases and their attendance in this economics program to identify the training impact. And we'll use an event studies approach using the exact year of their attendance and examine if there are significant pre-trends. Then we'll have post-elastic net controls that are predictive of their attendance and the timing of attendance, fully interacted with year fixed effects. So if you're worried that Republican judges all choose to go in 1976 when the program started, we'll have time shifters for these biographical features that might be predictive of attendance and also of the outcomes. In other analyses, you can also look at a long difference approach, taking a page from economic history to see if there's a pent-up demand for economics, to see if ever attenders are deciding differently before the program started. And you can also use the changes in instructors, which is unlikely to be anticipated. So Milton Friedman was a prominent drug liberalization advocate, and you can see if the Friedman trainees are deciding differently than the non-Friedman trainees. We'll then take a page from experimental economics, looking at a policy change that gave judges significantly more discretion. So more specifically, we'll use an event study of the 2005 Booker Supreme Court decision that made mandatory sentencing guidelines only advisory. And we'll see that economics-trained judges significantly increase their sentencing severity relative to their non-economics counterparts. So not for this paper, but just to give you a sense of the rich tapestry that the federal circuits provide as a natural laboratory, would be to examine the random panel composition, to examine peer influence, and the exogenous seating network to identify learning effects. Was there a trained judge on your previous panel? And the reason you can do this is because the case law is like a giant book that you can clip by page number. It's also an airplane seating chart. So you can see if a judge sitting in 10F, that's economics trained, affects the judge in 10D, the next case sitting on 10 ABC. But this also means you can use topic ordering to identify mimetic effects. So topics are not randomly ordered, but judges are randomly assigned. So imagine the antitrust cases are the prime numbers. We'd examine if the previous prime number that you sat on had an economics training, as opposed to the previous prime number in the circuit having economics training, to identify the phrases that move across topics and the direction of transmission. There's also other aspects of the data that allow looking at the mechanisms of persuasion, the associations that judges may have with certain concepts, the genealogy of ideas, and mitosis of ideology. So here's the public perception of the program on a beach in the south of Miami with large corporate donors. Here's the perception put forward by the program. Milton Friedman giving lectures to judges, receiving homework assignments late at night. For 3 weeks, 19 federal judges from around the country took a grueling 6 days a week course in economics, with classes starting at 9 a.m. and sometimes ending at 10 p.m. The judges received the equivalent of a full semester at the college level. And from the beginning, judges, many of them 60 years or older, behaved like students, deferring to their teachers. So the program ran continuously from 1976 to 1998, with lectures by Milton Friedman, Paul Samuelson, and many other economic luminaries. And they covered basic economic concepts. By 1990, 40% of sitting federal judges had attended, which means by the mid-1990s, 66% of panels had an economics trained judge. Now you can see the dots start to decline. That's not because the judges stopped going. It's just that the program changed dramatically in 1999 to being only 2 to 3 days at a time. There are testimonies from judges' letters expressing how much they appreciated and learned from the program. Ruth Bader Ginsburg said how the instruction was more intense than the Florida sun. We can also look at predictors of attendance. Republicans are a little bit more likely to attend, but that's not the most significant predictor. Birth cohort. So the really older judges are less likely to attend, perhaps they're about to retire, and the really young judges are less likely to attend, perhaps because they're already receiving it in the law schools. You can also observe the syllabi, and it seems to cover basic economic concepts, but as many instructors know, it's not about the content of the syllabi, but it's about how you teach the materials. And the founder of the program was quite prominent in advocating for insider trading, being economically efficient, that profit is the only decent measure of real public benefit. Other instructors would talk about discrimination and punishment being analyzed in terms of economic efficiency, leading to the conclusion that society will institute unequal punishments for equal crimes. Other instructors would be emphatic on, I'm trying to change your view of the world to show you what you thought was bad really may not be. And they gave the received wisdom on antitrust, that price discrimination that encourages more production is good, that simple damages may not be a tough enough deterrent. They gave some surprising quotations on environmental regulations that may have been undergoing a lot of ferment in the 1970s. And as a testimony to the impact, judges fresh out of the program included a diagram of marginal and average cost curves, their first significant opinion in history to do that. So now let me turn to the econometrics. So we're going to look at the outcome for case I by Judge J in court C during year T, something like voting against regulatory agencies or conservative or liberal votes. We'll look at this in a difference in differences manner, as well as in event studies. So we'll have judge fixed effects, court year fixed effects, and an indicator of whether the judge attended the training program turning on after they attend. We'll also have machine learning selected judge covariates interacted with the year. And we'll have an event studies framework that uses leads and lags of the program attendance, excluding the year before attendance, so we can look for pre-trends. And the regressions are weighted to account for caseload differences across courts and years, and standard errors are clustered by judge. So what do we see? We're going to look at opinions of the circuit judges, we'll look at the decisions of the circuit judges, and we'll look at sentencing in the district courts. In the opinions, we'll use a set of phrases that legal scholarship has identified as carriers of law and economics ideas. And we'll use word embeddings that represent the text in a low-dimensional space. And we'll use the vector representation of the words identified by the legal scholars and see if the vector, that's the average of the words in the law and economics lexicon, is more or less closely associated with the vector representation of the case. And you can see from the lower right that things like cost, efficiency, market, marketplace are intuitively associated with the law and economics text. In the outcomes, we're going to see that upon going to the Manny program, judges are starting to use more economics language. So the blue dots are the baseline specification with judge fixed effects and circuit year fixed effects. The red diamonds also add the elastic net controls fully interacted with year fixed effects. You can see that the effects are quite stable. Turning to the decisions, we'll look at the conservative vote direction in the 5% sample by the Sanger-Auburn team. We'll have voting against regulatory agencies, that's more sort of black and white from the regex from the title of the case. And we'll have antitrust rulings from a newly annotated data set on voting for or against mergers. And we can observe that upon attending, they start to vote more conservative in economics cases, but not non-economics cases. So if you think of the Chicago Law Economics School as being a more libertarian philosophy, then you might actually expect them to vote more liberally on civil rights issues, which is potentially explaining what we see. When we look at ruling against labor and environmental agencies, we can see that the economics training is getting them to vote against labor and environmental agencies. And you can also see that it's not that they got a bunch of tools, a language that justifies a pre-existing predilection to vote against the labor and environmental agencies, but they actually switched the direction of their votes. This is also robust to judge-specific time trends. And then turning to antitrust decisions, we can see that economics training is getting the vote in favor of mergers. Looking at sentencing decisions, we can see that economic trained judges are now more likely to give any prison and also assigning longer sentence lengths. And looking at the Booker ruling that made this very dense guideline only advisory. So basically looking at the criminal defendant's history and also the criminal offense, judges were told this is the minimum and maximum sentence you should promulgate. And this was deemed unconstitutional. And so what we'll use is the event study giving the economics and non-economics judges much more discretion in how they'd like to sentence. We see no significant effects on the extensive margin of any prison length, but significant effects on the sentence length. Economics trained judges are becoming harsher relative to the non-economics counterparts. So we also have a number of other analyses and robustness checks. We find no effect on other academic language based on similarity to law review articles, nor on their use of statistical or quantitative language, no effect on citing the US Constitution or Bill of Rights, if you think that it might be some originalism philosophy that is being espoused, no effect on citing judges appointed by Reagan or Bush Sr. We see a positive effect on the conservative dissent rate, that is dissenting against the majority opinion authored by Democrat-appointed judges. We can also do a number of robustness checks, dropping circuits that some authors argue to violate random assignment, do alternative ways of clustering for the standard errors, weight or not weight the regressions for the caseload, dropping judges with the smallest and largest caseloads, adding fixed effects for legal topics or crime types, and adding judge-specific time trends. Because we're doing the event studies, we also account for the fact that there might be heterogeneous treatment effects. So the early attendees may have a very large treatment effect, and the early attendees are now at the control for the later attendees, which might lead to some bias in the average treatment effects. But we use the standard methods to check, and we don't find these to be a significant concern. So to conclude, we see that economics language in academic articles are now adopted in judges' opinions. We see economics trained judges changing their decisions in these high-stakes settings. Economics likely change how they perceive the consequences of their decisions. In economics cases, economics training changed by 10% the direction of their votes. So if you teach judges that markets work, they'll vote to deregulate government. If you teach judges deterrence works, they'll become harsher to criminal defendants. And in the district courts, when judges had sentencing discretion, economics trained judges immediately rendered almost 20% longer sentences relative to their non-economics counterparts. And economics training accounts for a substantial portion of the great transformation of American law. So if you look at the Sanger-Auburn database and you look at the increasing share of conservative votes, about 25 to 33% of these could be explained by the Manny training program. So thank you, and look forward to the questions.
Great. Thank you, Daniel. Let me start off with some questions and comments. I've kind of made one comment already, and I would encourage you when you revise the paper to, if you're going to, every place you have the word conservative, replace it by something more specific or say what you mean. I don't think it means the same thing in all the context that you use the word. And just as a reader, I didn't find it helpful in understanding what you were saying. And what you were testing at various points in time. Second, I suspect you've overdrawn the distinction between the duty-bound versus consequentialist views. And I may be wrong about this, but at least you haven't made your case fully. And here's what I'd like to see to make the case. I suspect that in many cases, the issues are essentially consequentialist and not a matter of duty within the things that are being decided at the circuit court level. So the clearest example of this to me, and I'm not a legal scholar by any means, but would be antitrust cases where the law explicitly instructs the judge to apply a rule of reason approach. That's not about duties. That's basically about weighing off different consumer welfare or even economic efficiency criteria. Now, maybe you're going to tell me that the rule of reason approach itself grew out of the law and economics movement. And to some extent, I think that's true, but I also have the impression that the rule of reason approach to some antitrust cases predates the Mann program, for example. So, and then more generally, I wonder how many of these, so here's the alternative view that may cover part of what you're finding in your data, which is judges by this program and by economics programs in general are being equipped to perform, they're being better equipped to undertake consequential analyses and judgments of the evidence in reaching their decisions, okay? And that's slightly different than the dichotomy you set up to start with. So you could have, for example, and again, I think the antitrust cases that had come down to a rule of reason are a very clear example, because they're not really about the duty part. They're about weighing pros and cons in an economic sense. And getting economics training may alter your view of different kinds of evidence, okay? So I have another question, but let me stop there and get a response to that one.
Great. So first, here's a little bit more information about what is a conservative vote. And fair enough, we can certainly unpack the notion of conservative in future drafts or appendices to look at all the different flavors. This is a very kind of a detailed rubric that Sanger Auburn had set out. So for those that are just listening, rejecting a defendant in a criminal procedure case, rejecting a plaintiff asserting a violation of First Amendment rights, rejecting the Secretary of Labor who sues a corporation for a violation of child labor regulations. Second, fair enough on the duty versus consequences. The reason I started with the metaphor is because, at least when I was in law school, 3 of my 1L classes used that metaphor to illustrate law and economics thinking versus the quote unquote alternative, which, as you can see from here, do we really know how the judges are thinking when they previously were positing that, there's a general obligation to keep promises, that there's this duty, that there are these different, books or treatises that talk about this, very, very broad, magnanimous concept of the word duty, but maybe actuality, they're just using this as language, but consequences are what drives the decisions. And that's not something that, one can really take a stance on without more information about the behavioral mechanisms underlying the judge's rulings.
But you have the text in these cases, so you could try to sort these cases into those where the judge is actually discussing whether it's a matter of duty or a matter of consequences, or the entire opinion is just about different ways to evaluate consequences. It would be helpful to know, for example, are 75% of the cases a struggle between duty and consequences, or is it only 10% of the cases? Because it would lead to very different interpretations of your evidence. So that's what I'm looking for. I think the text-based approach is actually well suited to giving us some sense of that. Maybe the people in law and economics already have some sense of what cases are about. I don't, as an outsider coming at this. So
great. Thanks.
Let me turn to a different issue. And it's kind of, what's the economic approach about? So, and what constitutes the influence of an economics approach on judge-making behavior and decisions? So if I understood you correctly, you equated the economics approach in the criminal sentencing area with longer sentences. And you seem to have some evidence, if I correct me if I'm wrong, that judges who passed through the Mann program were more likely to assess longer sentences for persons who were convicted of criminal offenses afterwards than before. It's not clear to me that follows naturally from economics training. So when I think about an economics approach to sentencing and sentence length, there's three basic things that come to mind. One that you talk about a lot, which is the deterrent effect. You know, a rational person contemplating a criminal act would, in the economics view, consider the probability of being caught and the sentence conditional on being caught and convicted. Okay, that's an element of the economics approach. Another very simple element is the longer you keep a criminal off the street, somebody who's been convicted of a crime, the longer they can't commit another crime against the general population. That's a basic economic approach. It cuts in the same direction as the deterrent effect. And then a third approach, not a third approach, but a third element in economic decision-making would be, there may be a tendency for greater recidivism once you're released from prison, the longer you've been in prison. And that effect, you know, can go either way. Obviously, if you keep someone in prison until they die, then recidivism is not an issue. But it may well be an issue between a 6-month sentence and a 2-year sentence. The increase in this is just an issue. It's a matter of evidence. The increase in recidivism from a 2-year sentence relative to a 6-month sentence may be sufficiently high that you're actually going to have, in expected value terms, more criminal acts with a longer sentence than a shorter sentence. So these are all elements of what I think of as a rather basic economic approach to sentencing. And they don't lead to an unambiguous conclusion about what economics training does to sentencing lengths. What may happen in these Mann programs, and I'd like you to speak to this if you could, is not just that the judges that pass through these programs are being exposed to economic ideas, but they're being exposed to evidence on the force of different economic effects, like the three I just mentioned in the criminal justice setting, or as some of your quotations illustrated, they're being exposed to the use of statistical inference methods to reach judgments about how to weigh different types of economic evidence. So again, like my previous comment, all of this is consistent with the idea that the Mann program has important effects on judge decision-making, but not necessarily because it's shifting them away from non-economic to economic considerations. It's just, in this example, the criminal sentencing may lead them to weigh different kinds of evidence differently than they would have before the program.
Okay, let me try to respond to different parts of the important thought bubble that you're sharing. So firstly, this is very, very much black box. There's so many different moving pieces to the program itself that, it's hard to really say what's going on. You can just consider a lot of the results as sort of a reduced form impact of the training program on things that we observe in terms of the decisions, how they write, and sentencing. So the second, fully agree that there are different ways that economics thinking could potentially influence sentencing. In fact, one of our initial presuppositions is that fines rather than imprisonment would be sort of quote unquote economically efficient, but then there could be constraints on how you can fine, or maybe there is liquidity constraints. Whatever it may be, what we observe in the quotations from the testimonials and the newsletters from journalists that were attending the program is what you see both on the slide deck and also in the appendix of the paper. Your other point about empirical evidence and the use and the tools. For sure, Oli Ashenfelter and another prominent legal scholar, empirical scholar, were teaching a very small module of this extended program. And according to the quotations from the newsletters, it would be like, how do you understand the price of wine or something? And you run a regression with, coverts on the right-hand side. What I do find interesting is this empirical skepticism that's being conveyed on equal opportunity and discrimination, but you don't really see quotations in the newsletters to be empirically probing when it comes to other aspects of economic regulation like antitrust. And did they actually get the tools to do more empirical analyses in a sharp manner? We do look at whether they start to employ more statistical and quantitative language. We see that they don't. In fact, if anything, it becomes slightly a negative effect upon economics training. So all this is to say is that, the most important thing at the top of this slide, we can't say normatively in some very, very broad sense of the word, what is the potential, benefit of the training program or detriment. This is, of course, going to depend on your stance, your normative commitments, on what you think was the right policies, beforehand. Nor can we say that this is economics, capital E, its impact. This is just a very sort of point in time movement in the 1970s and 80s that seemed to inject a then considered new set of ideas that gave them, a better toolkit to analyze the problems that they're already confronting. And from the testimony of the judges, they were very, very appreciative of getting these tools to better analyze the potential economic effects. But they weren't given the empirical tools to actually quantitatively estimate that. But that's a whole nother frontier that I hope someone on the audience would explore, or maybe new movements and programs can teach judges how to evaluate the empirical evidence more carefully and more directly. To your point on criminal sentencing, if judges are asked or writing out, this is what I think, this is what I think, this is what I think on each of those dimensions, then of course would you be able to really, really get at the mechanism that you're asking.
Yeah, let me see if Justin's got comments or questions, and then while he's speaking, I'll look over the Q&A.
Awesome. Okay, yeah, I have a series of questions that I think are related. So you talk about it a little bit in the paper, but one of the big issues, obviously, with the language is thinking about how this would go to the clerks, because clerks are doing a lot of drafting of the language. Hoping you could just say a little bit more about how you're envisioning going from the sort of training that's happening at the MAN program to clerks, sort of producing the opinion where you'd have this language, sort of the envision like judges are, you say a little bit about selecting, and like clerks come from George Mason, more likely, but is there some other way in which the sort of clerks are imbibing this from the judge? Is it all selection?
Sure. As I understand it, often judges can set like an outline for the clerks to, fill in and do the legal research to, bring in the details for the document, but the judge is the one signing off and potentially drafting large amounts, if not the entirety. So that's Richard Posner, at least, would self-articulate he would draft everything.
So I think that makes sense. So it's like the system is that clerks aren't involved. I have, I think, a series of questions about what folks are learning at the program and how we think about that sort of first stage of them learning affecting your results. So one of the things that strikes me that they're learning isn't just about economics. They're learning that economics professors are very smart people, and they have thought about these things carefully, and they have analytic tools. And then those economics professors are often used as expert witnesses in these cases. And that therefore they should be trusted when expert witnesses, as opposed to making, decisions on cases based upon other sorts of criteria. So I'm curious if there's evidence that judges who attended this program rely on expert reports more, or they're more confident in entertaining like Daubert type motions that an expert doesn't know what they're talking about, in fact, or sort of over their skis in their motion, that sort of thing. So is there evidence that they shift their reasoning towards experts?
Yeah, that's a great question. So we haven't looked at that, both in terms of the text nor in terms of any kind of metadata that might allow us to see this information. I don't think that explains the entirety of the effects we observe, since we see in sentencing decisions that it's also affected. But that's a great next question to look at.
Yeah. So, I mean, obviously you want to sort of partition, is there an expert involved would be, another question, but even sometimes in, criminal proceedings, whatever, they can bring in an expert, depending on the situation. So I guess the effects are, on some accounts, very large, which leads me to wonder, this would be like the most effective college course ever delivered. When I, think about like delivering a course like this, I would be worried over the course of, the time of the program, that everyone would understand what I was saying and that they were like, paying attention, even though there's ostensibly long hours, they're still in Florida on vacation and hanging out with their friends, which usually is not a recipe for, deep uptake. So I'm curious if subsequent to attending the program does something to keep these judges together, or to keep sort of like redosing them like year after year. And if that's the case, there's a couple other things that could be interesting. Like, do these folks stay on the bench longer than other folks? In part because maybe they're part of this network and it's like adds some interesting components to it. And then the second thing is if they're sort of, redosing them or reminding them or trying to accentuate this, I'm curious if that's sending some signal about what potentially politically ambitious judges might think people who would be sympathetic to their movement through the court might be thinking.
Yeah. So in the paper, we do talk about the possibility that there is this network effect, that they were, sent these newsletters after they attended, that even the district court judges that receive training are more likely to be promoted under a Republican president than a Democrat president. But also in terms of the initial training itself, I can just present these quotations on how impactful they felt the program was. Gave me a principled basis for deciding close cases, a sound theoretical and rational structure, the potential effects of imposing a duty. I'm a social progressive, but the basic thing I've learned is that social good comes at a price, a social and economic cost. I never thought about this. Become a much better judge. I mean, sure, this could potentially, sort of all be cheap talk, but it's also just the fact that they're writing these back and are saved is, I think, kind of, I wasn't there in those programs to get really a sense of how intense those programs could be, but just imagining all the different, economic and quasi-economic issues that come up in judges' cases all the time already, and now they get something that sort of makes things a little bit more logical and rational for them. Wouldn't be surprised to see that this can have such a big impact, because they're already struggling with these issues, I think.
Okay, Steve, do you want to?
Yeah, I wanted to go to Aaron Carter. Aaron's got a bunch of questions and comments, and can we give the microphone to Aaron? Let her pose her comments and questions. Go ahead, Aaron.
Hi, everybody. Thank you so much, Daniel, for this really fascinating presentation. Just to be helpful, I wrote a bunch of reactions in the chat box, but I'll just pick one for the sake of discussion. Justin alluded to this a little bit. I'm really interested in whether you see any decay effects of this program over time. And I didn't think of this at the time, but what Justin was saying made me think that I'm a little bit concerned that maybe people join this program for some sort of career signaling mechanism, like, I'm signaling that I'm conservative or I'm open to conservative arguments. Maybe that will help me in my future judicial career. So I was thinking of the two things that might be interesting to look at. One would be, can you show us the decay effects, and are there any heterogeneities in the decay? And two is, if you focus just on the people, probably a small number, who took the training program at the very end of their careers, they wouldn't be subject to any career signaling incentives, since they would probably retire soon. So I'm curious if you find any different effects for those folks. Thank you.
Yeah, that's a great set of questions. Firstly, we do observe some of a decay effect, but part of this is because the control judges are, or sorry, that's not the right term here for recording, but those who didn't attend are also receiving economics ideas from their colleagues, the young judges and so forth coming forward, and also the fact that they have to cite and read and bounce ideas off of their fellow judges who received this Manny economics training program. In terms of heterogeneities, we haven't spent too much time looking at that, though we do see that there are some intriguing differences that when you look at the conservative vote increase and conservative rulings on regulations that's driven by Democrat appointees, and the criminal sentencing increase seems to be driven by Republican appointees. And then your final question about age, we haven't looked at that, but that's something that could be interesting to examine.
Aaron, did you have more comments or questions? If you do, go ahead. Otherwise, I'll jump in with another one.
Why don't you, Steve? I had a bunch, but they're in the chat box. There are probably too many of them. So why don't we hear for some others?
Yeah. Okay. So this is you didn't say much about the heterogeneity and the responses of the judge to the program, but presumably there is. So if you sweep out the main fixed effects, and then look at and essentially get a before-after comparison for each judge, it'd be useful. And instead of taking one case at a time, just let's say take all their criminal justice sentencing cases in the 3 or 4 years before the program, the 3 or 4 years after the program, and then show us the distribution of. So there's a mean before and a mean after. So take the differential and the means, and show us that the histogram or the kernel density plot of those changes across judges. Just to get into the issue of, there's two things here. First, are we getting small effects on most judges, or very large effects on a few judges and essentially no effect on other judges? I'd like to kind of know which of those cases is closer to what the data look like. But the other thing I would do is I would then take maybe the 50 judges where this program had the biggest effects, and I'd do a deep dive on their opinions before and after they took the program. You could do this with criminal justice sentencing, but you could also do it with other areas. And you can do this with human readings, but it'd be nice if you could use some automated methods as well. And again, I want to get in more. It seems to me you don't really exploit the text in the judicial decisions, the judicial opinions, very fully to understand what the Mann program is actually doing. And this is one way to do that, to pick out the big movers, so to speak. And if you can't figure out how to do it in an automated way, then just do it with manual readings. I'd really like to know what's going on. To what extent is it that they're shifting away from deontological perspectives to consequentialist ones, or are they just altering the way they make decisions within a consequentialist perspective? Are they really bringing economic principles to bear that are new to their writings, or are they just weighing types of evidence differently? Justin's point about how much weight they give to expert opinions would be one example of how they might shift the weights they place on different kinds of evidence. I don't know, maybe you've already done this histogram Daniel, and you can tell us what it looks like.
Yeah, you can see I'm flipping between slides and paper material to screen share, answering these questions. Zoom makes it so easy. So I take your question as to be interpreted in two different directions. One direction is, what's actually going on in the text, potentially being impacted by training. In the appendix, we do a few things looking at just to pull out some examples of which sentences are like closest to this Elkson law and economics metric that I was screen sharing earlier. Sorry, it's a little small to read, and there won't really be time for me to read this type of text out loud, but it gives you the potential to examine more of this. The other direction I interpret this is, are there outlier judges, but sort of in a bad way, which is, your effects are not, sort of robust because it's like, a single person who's sort of largely affected. We haven't done the histogram thing that you're talking about, which I think is interesting and worth doing. We do have this old graph that was doing this long difference approach, meaning, after the training program, do you see substantial effects or associations, but before the training program, the ever attenders, are they already showing that positive association? You don't really see this. And the reason I'm showing this is bin scatters are a useful technique to give you a sense of, are there outliers? It's all driven sort of somewhere in the distribution. But no, this is a really interesting direction to go in. We can think of this as the first step of looking at the impact of this Manny program on how judges decide, and then to further probe into what exactly they're doing is really, really interesting.
Aaron, you had a whole bunch of comments.
Yeah, sure.
I'm sure you have other good ones, so go ahead.
I'll do my best here. I think just one of the comments that follows on what Steve was saying is that I think one way you could actually get a lot of traction on that would be to use a distinctiveness algorithm. So basically, you take a judge, and you're doing like a within judge analysis, and you look at all of their opinions and writings and like the years before and after they attended, and like within that judge, do distinctiveness on that corpora of those corpora of text, so you get the terms that are most distinctive to their writing. So I think that would help you very, in a descriptive sense, pull out what exactly is changing in their economic analysis over time. And that would also get to Steve's histogram point about, are there some judges who have these huge changes and others who are much less so? That would at the very least help you identify which judges you want to do a deep dive into. So I think that would be quite interesting. So I'm curious also, so there are other changes, I'm not an expert in the legal profession, but there are other changes going on at the same time. And this, in a way, this paper is kind of similar to the literature on lobbying that goes on in politics. There are like lots of different places for intervention. If you want to make the American judiciary be more conservative, this is kind of an end stage intervention. You're focusing on people who are already practicing professionals. But there are a lot of changes going on, I would presume, in law schools as well, or earlier training programs. So I'm curious if you've thought about other interventions that are going on at the same time, such as changes in law school curricula. And I don't know if you're able to get data on that, where people went to law school, the courses they took, or the general sort of approach of that school. But it'd be interesting to look at any heterogeneities there as well. Are people who are already trained in a relatively more conservative approach to the law, are they having bigger effects, smaller effects? They select differently into these programs. I'm just curious about how you think about other interventions that are going on at the same time.
Yeah. So we do have the law schools, and one idea a long time ago was to try to find out if you can get what courses they took, but that's unfortunately not available. We have also thought about the potential interpretation of this as, sort of lobbying, though we don't think that this is, again, it's not explaining the entirety of the effects, especially when it comes to the sentencing decisions. And also, point taken on like the first comment, which is to sort of further go in Steve's direction and sort of outlier detection, but this case for a judge before and after he or she attends the program. The other question you asked was, are there other things that are going on at the same time that would be potentially associated with the Manny program? As far as we're aware, this was the most salient training program in its at that time in its heyday, but obviously we can only, as the data as, we don't have that information for, oh, they went to the managed training program and then right afterwards they went over to another program or something, which we don't observe. But as far as we know, this is the most important program in its at its heyday then.
Okay, we've got a comment from Elizabeth Elder. Derek, can we let Elizabeth have the mic?
Great, thanks. So I'm very curious about this idea that one of the judge participant quotes seem to be hinting at, which is that maybe some of these judges already wanted to make conservative decisions, but just didn't have a rationale they felt good about until they went to this program that provided them with like a theoretical basis or a well-founded basis for them to make that decision. And I would love to see more evidence that could tease out this particular mechanism about like the availability of a form of reasoning rather than something else about career or about networks or exposure to other parts of what participating in this program might entail. So I don't really know anything about like these legal theories and when they came about and how widely known there were, but if there's some way to compare based on when they took the training, were different like economic rationales that were available kind of more or less well known, how likely would it be that the program was a judge's first exposure to this form of reasoning? I can imagine that might change over the course of your period of time as these become more broadly known in the public. You could tell whether the effects are different or larger if it's more likely that the program was the judge's first exposure to that argument versus in other areas where arguments like that were already well known.
Great. So I really like, all aspects of the question I really like, but that final one was basically to look at, say, the fraction of their peers that were previous attendees in the circuit, or, in the last 6 months through your random assignment, how many of those peers actually attended the training program. That'd be one way to capture this exposure to the ideas, which we haven't done. Your first comment, I'm not sure which of the quotes you felt was, I got a set of reasons to justify a pre-existing predilection. If anything, the quotes, I mean, again, you should feel free to, you don't need a lawyer because you can just see all of these itself. But I regard myself as a social progressive. All the colleagues were of a conservative persuasion, but the class wanted to express our gratitude. And then the person who rose to speak was a judge, without a doubt. He was a Democrat going back to the medieval days. So if anything, it seems like it would be potentially switching the direction of their decisions. And that's actually, what we're showing here in terms of ruling against labor and environmental agencies. But fair enough. If you think that there are ways we can examine that, there's like me just getting a set of tools to help justify a set of a way we're going to vote, we can certainly think about that more, but it's not clear from these.
No, that's totally fair. And I think I'm probably reading more into this than the text really says, but just this idea of, a principled basis for deciding close cases sounds like maybe I like wanted to decide one way, but didn't have a principle with which I could do so. Okay. And, like I said, I probably am reading too far into this, but this is an idea that shows up in a lot of different areas of politics, I think, that people kind of feel one way and need to explain it to people with something reasonable in order to actually kind of express that. And I can imagine that happening also with judges. So I'm sure that's not happening all that's going on here or happening to all of the judges, but I just thought it made me curious about whether that was something you could pick up on.
So maybe this would be one way to use the heterogeneity on these effects, for instance. But I will say that as a former law student who was reading all these really old cases, you can see judges are in fact struggling with economic concepts, and they just spend 10 times more words than you might actually need. And I would think that is one way to interpret this quotation, is giving just a little bit more structure for thinking about those issues.
That makes a lot of sense. Thanks so much.
Daniel, just one last question. It's related to this. line of discussion, you mentioned that something like half of all federal judges had gone through the demand program at one point. The program was routinely oversubscribed. All that points to a huge latent demand for economics instruction among federal judges. And presumably that demand would have been met some way or another, even if the demand program itself wasn't there, at least partially, maybe not in the same way as the demand program. But do you have a sense of where this groundswell of latent demand for economics training came from during this period? Is it like somehow people like Milton Friedman and Paul Samuelson through the Newsweek columns had convinced judges that economics had a lot to offer that they didn't know about? What it's really outside the scope of your paper a bit, but it's closely related to it. Why all this interest in economics training?
I mean, I can only speculate, but in the 1970s, stagflation was a big deal. I think Milton Friedman had a TV show. I mean, there's different ways to kind of think of that moment, and then these prominent economic scholars availing themselves to teach the TV show in a more rigorous way for the judges, and just seeing so many of the things around them as being potentially inflected with economic concerns, and therefore imbibing and listening, being ready to absorb all the materials that were being taught to them. That would be one speculation for what was going on in this time period. Okay, very good. All right. Well, thanks so much. We're going to close the formal session now, the recorded session, the session that will be available for text analysis in the future, and go to an unrecorded segment now. Okay, anybody who wants to can stick around. Thanks.